Hello. There is one common misconception, I would say, or at least misunderstanding, that sometimes plays an unfortunate role in somebody's chances to get the justice in court. This misunderstanding or misconception is in connection with the idea of restorative versus preventive justice. In short, uh, preventive justice is supposed to stop some unlawful act or action or even intent in advance before some damage actually happens, while restorative justice is only intended to correct, as much as it is possible, that wrong, like in the hindsight. For example, in the situation of preventive justice, uh, some fraud would be stopped before even you have delivered your money to the fraudster. In a restorative justice, you apply after the fact, and after a long trial, the judge orders the other party to give you back your money and maybe something more in compensation for all your trouble, something like that. So, our justice system, at least our civil justice system, is a restorative justice system. It does not act in advance. It does not act like mostly. There are nuances. You have to consult your lawyer if you have some particular facts, but generally, it does not act in advance. And even though in the civil justice, in the civil law justice system, there is no such a thing, like technically, as presumption of innocence. It's more a constitutional right when it comes to criminal justice. There is a similar thing, at least in Quebec uh, civil code and in Quebec civil law system, uh, which tells us that the good faith is presumed, meaning that unless proven otherwise, the other party is presumed to have acted like based on good lawful intentions, though sometimes there is a situation of strict liability. So when there is no even a fault, some consequences of somebody's actions still attract some responsibility. But mostly, if there is no fault, then there is no responsibility. And no fault, the good faith, sort of, there are nuances, but in general, good faith is presumed. So if somebody wants to hold somebody else responsible, the one who is attacked, the demanding party, should prove that the demanding party has had a right and the other party like violated that right, wronged the other party, so was at fault, and that some damage was caused and the amount of that damage. So everything should be proven by the party in the attack. And as you can see, in such a situation, preventive justice is not even possible, because until proven otherwise, the other party is presumed to be innocent, like in good faith. And as the other party is presumed to be in good faith, there is no reason to prevent that party from acting, from doing something that is presumed to be technically lawful, like without fault. So, to many people's disappointment, I would say, there are situations when something bad is happening, but there is no legal reason for the court to put a stop on that. Because at this point, it was not yet proven that the other party was not acting in good faith. the other party was acting at fault somehow. And as long as later at the final trial, by the judgment, the judge in the hindsight could restore justice, like correct the wrong done, then the system is considered to be working properly. Of course, there are situations where injunctions are needed. There is another video about that here. But again, those situations are considered to be exceptional. The general rule is that the justice is restorative, that the courts, the justice system interferes afterwards upon certain proof that some right was violated, that some fault has happened and caused some damage, and only after everything is there and proven, then the court might restore justice back to normal. Thank you and have a nice day.